Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press. The title of the book is Macdonald on the Law of Freedom of Information. It's now in a third edition and it's been written by John Macdonald, Queen's Counsel, and Ross Crail. As I've indicated, it's a hardback book and it's come to us from OUP. We have reviewed books, the editions in the past of this work, and Elizabeth and I talked about this book and we've given it this title for the review of the third edition. It's a comprehensive exposition of freedom of information law, now in a new third edition from Oxford University Press. Let's have a look at the book first. It's a hardback and it's a heavy book. There's the front, red cover, front, and you've got the spine there. Now the book itself, as I say, is heavy. It runs to something approaching 850 pages. There's the index at the back, and it's a big index. You should be able to find everything you're looking for here quite easily. Then there are chapters, and this is the last chapter right at the back, chapter 26. You can see that there is paragraph numbering at the sides, and there is in fact a conclusion section in quite a large number of the chapters. There are some footnotes which you can see right at the back at the bottom there, which are of help. Let's go to the front of the book and we can see the number of people involved. Can I just say the people who've contributed are Ian Peacock, Edwin Simpson, Adrian Pay, Simon Adamick, Charlotte Ford, Anna Littler and Gabriella McNichols, and they're barristers from New Square Chambers in London. So they've all put a lot of work into this book. There's a foreword to the first edition from Richard Scott, who will be known to many people, and then there's a main preface which sets out, in fact he starts by referring to Professor Wade, drawing attention to the difficulties which British law puts in the way of the ordinary citizen trying to obtain or use information in government hands, and that hasn't changed. And there is the little statement there. Now here is the main part of the contents, which you can see there. It's set into parts A, B and C and so forth, and chapter headings. That's the first page there, and you've got again you can see how it's running through. Human rights of course play a very substantial area. You've got details on statutes, and then right at the back, final chapter is on the future, and then you've got tables of cases, a lot of case law, and they're based cases coming not just from our jurisdiction in England and Wales, but also from Commonwealth and other jurisdictions, and quite a large number of cases. Then legislation, as usual, to be expected, and you've also got, in addition to that, quite a large amount of legislation. You've got a very useful list of abbreviations. There's a lot of abbreviation about these days in the law, and it is useful therefore to have some idea of what the abbreviations mean. There's the second page of it. Then you go straight into it, an introduction to the Freedom of Information Act 2000. So he kicks it off, and what you've got with each chapter, as you can see, you've got a little mini index. So you should be able to find things very quickly when you're looking at anything particular. And in fact this is a nice quote from Lord Sumption. The Freedom of Information Act 2000 was a landmark enactment of great constitutional significance for the United Kingdom. And again they then go on and explain in some detail what it means. There's been a lot of sniggering about the law of freedom of information over the years, starting with Yes Minister, where the whole point of it was that it was not freedom of information. But we are in a position now, because Whitehall and the government is seen to be excessively secretive to some people, we are seen to have acted upon some aspects, but it's certainly not as open as some people will like. So what is the book about? Well, we've had a fresh review of the work, and this is what we say. In a recent decision, the Supreme Court has in effect tipped the uneasy balance between privacy and freedom of speech in favour of the former, that is privacy. Now we know the case involved, and an injunction is now in place which prevents people in England and Wales from reading about what people in Scotland can read about and what people in virtually the rest of the world can read about via the internet. Now, this is a question of freedom. It's not just a question of anything other than a principle. Now, it seems a strange decision to some, especially for readers of the new edition of Macdonald on the Law of Freedom of Information. It's been published by OUP, the Oxford University Press, and the latest edition of what is now a definitive work it's on a subject which has engendered considerable controversy and public concern. As I've said, Lord Sumption is quoted, and Macdonald stresses that information is the key to sound decision making, to accountability and development. It underpins democracy, but information can be genuinely private, confidential or sensitive, and these interests merit respect in their own right. Now, when we're talking about privacy and freedom, it's not just about people in the private domain, it's about the public sector as well. And it's a balance between the competing considerations of privacy and free speech, adds the author, and the balance between them which lie at the heart of this third edition. And I think that is actually a very useful starting off point for where we are in 2016, because I don't think this decision that has been made, which has it's going to have a lot of implications. It hasn't ended the debate at all. It's probably just started a whole round of new arguments about where we draw the line between privacy and the right to know what's going on. Again, it's whether it's a person's private life or whether it's a public matter. So having taken all that into account, in the light of all of this, the aforementioned Supreme Court decision strikes a cacophonous note, for it seems that privacy of late has triumphed over transparency, and that of course is the jurisprudential issue and the hard case. The judgment is especially odd in that the Supreme Court is one of the few courts in England and Wales that have cameras positioned all over the place with a view to recording the proceedings therein, and excellent it is too, a very good step forward. Also consider the mighty struggle for free speech over the past few hundred years. The 17th century poet of Paradise Lost, John Milton, who wrote the famous anti-censorship tract Areopagitica, which I can't pronounce that properly, never mind. It must be turning over in his grave, having seen what is happening. Oh well, even Supreme Courts make mistakes, and I hope I can pronounce the title of his tract properly another time. What is especially interesting about this well-established and ever up-to-date work of reference is its ending, as the author and his team of expert contributors from New Square consider thoughts on the future in the last chapter. It's right at the end. I pointed it out when we were looking at the book. There's more than one juicy Sir Humphrey-like quote in there, and elsewhere from certain government sources, including one from Lord Briggs. Our aim, he has said, is to be as open as possible on the substance consistent with ensuring that a private space is protected for frank advice. Now, reading between the lines, say the book's editorial team, the Treasury see an opportunity to charge people more if they seek information. That is what has happened. There's a fee for it. The more they are charged, the less information they will seek and the less trouble they will cause. We make no further comment here about that. But again, there will be a strand of opinion that says, why do we have to pay for it? Well, of course, there's work involved in producing the information. But again, if it's public, we are, as the electorate, we are the final payers of the bills. So perhaps there shouldn't be a fee. But I'm sure the Treasury wouldn't agree with that for one moment. Now, writing in the foreword, Richard Scott describes the book as a comprehensive exposition of freedom of information law, and as such invaluable to the practitioner, also pointing out that although it is arguably a practitioner's book, its simple, clear language will make it accessible to lawyers and non-lawyers alike. Logically organised, with extensive footnoting, numbered paragraphs, a detailed table of contents and an index. The book is easily navigable and contains a wealth of research resources, including over 60 pages of cases and legislation, as I've indicated, from a number of jurisdictions, as well as a table of conventions and agreements. And I think it's important to note in Part A, right at the beginning, which is the introduction to the pivotal Freedom of Information Act 2000, which is where the big book rightly begins. Now, let me conclude by saying that certainly the book's comprehensiveness and erudition make it a must-have for any practitioner, or indeed any reader interested in this continually expanding, consistently complex and certainly topical area of law, and its influence or lack of it within a relentlessly changing media environment. You haven't heard anything yet, in my view, about all of this. We're probably just at the beginning of a series of problems. The difficulty, probably, I'm recording this after the referendum decision and Britain's leaving of the European Union, which is going to cause a lot of interest. But what did come out of it possibly is the concerns the ordinary people have about being ruled by an elite. And that is something, again, this is part of what we have with freedom of information, keeping things secret, we know best and you do as you're told and all that sort of stuff. It may well be that things change, and quicker than one might think. However, I ponder on that and leave you with that thought. The publication date is cited at the 4th of February 2016. Here's the book again. It's a delightful book. It's easy to read too. I mean, some of these books are not, but this one, that's why I'm reviewing this book, because it's a good book. There's the front, there's the spine, there's nothing on the back. And it's just opening it in the middle. There's a case, recent cases and statutes. Are David Davis MP and others versus Home Secretary. There we go. Interesting information there. See, very current, quite political as well, because this is about politics. I know it's called public law, and there are other issues, which is jurisprudence, legal theory, and so forth. But there's a lot of politics in this to a certain extent. We've got the Official Secrets Act, 1989, and we've got all sorts of other little things. But let me just show you the bit at the back, because I did think that the future is what we're doing. There is a conclusions section right at the back. To sum up, the following changes are proposed. So there are actually 11 proposals which they're putting forward to amend the current legislation. And they say right at the end, as Aristotle said, even when laws have been written down, they ought not always to remain unaltered. Absolutely right. And on that basis, thank you to Macdonald and his team. This is an excellent publication, and thank you also to OUP. I'm sure you will find it very helpful, if not just as a general observation on where we are at the moment, but it may be directly relevant to anything that you are doing, especially in the public law field. So thank you to all concerned. Bye-bye.